psychiatrists and the mental health system. So I'm on the consumer side. I represent claims, and I've been through a number of proceedings involving local human rights committees where human rights complaints can go, and I will echo or take further what Mark said about the secrecy of those proceedings. I've faced a lot of challenges to keep those things private, and have pushed to keep those things public. So what I want to talk about today is sort of extrapolate a little bit from what Mark talked about, and I'm going to skip a couple slides because he's already covered some of this stuff, and I don't want to go over the same thing twice. And give you some of my thoughts on this, and also how this applies to other areas of practice, not just involuntary civil commitment, but other areas of practice as well. And then we'll get into some ethics when Barbara comes. We'll do some hypotheticals, and hopefully you all can get involved in that. And if you have any questions as we go, please let me know. Okay, so some of this I'm going to skip. This is what Mark already went over, but this is the language here. This is the standard for involuntary civil commitment as it is now. This is what it used to be. You probably remember the language: imminently dangerous to himself or others, or substantially unable to care for himself or herself. Now we've got this because, so you've got to have a mental illness, and it's important to realize that you can't just be mentally ill and be dangerous or a substantial likelihood. You have to have the mental illness because of the illness. There's a substantial likelihood that the person will, in the near future, cause serious physical harm to himself. So there's an element of causation that I think is important in the statute. It's not just that you have both, you've got to have one cause the other. And this is something Mark mentioned too. These are the elements that the judge can consider during the TDOs, DCOs, and involuntary civil commitment. This is widely expanded from what it was before. Doctor's recommendation, any past actions of the person, any past mental health treatment, hearsay evidence, and Mark's talking about this, where, do the rules of evidence apply? My position would be that this is eviscerating the rules of evidence. We can allow hearsay, any medical records, any affidavits, and all other relevant information. So you can see that this is widely cast the net to basically consider anything at all. And of course, the rules of evidence would not allow much of this to come in except under certain exceptions. This is what Mark was talking about too. Examiner is not required to attend the hearing, but shall be available for questioning whenever possible by telephone or two-way video audio communication. And these people can be psychiatrists, psychologists, nurse practitioner, clinical nurse specialists. It need not be an MD or even a PhD. Skip that. This is important, and it's something that Mark talked to, and it's disappointing to hear the lawyers that will say, well, my client really needs help, even though they're charged with representing that client, that each individual has a right to participate meaningfully in decisions regarding all aspects of services affecting him, request admission to or discharge from any service at any time. This would be especially true. I have a case now where a person was held in a mental hospital in the state here, didn't speak any English, and was unable to meaningfully participate in the treatment plan that was being formulated. And that's an issue that I have been fighting about there. And it would especially come true if you've got an Ethiopian, that was your example, can't speak English, doesn't understand what's going on. It would be especially important for that person to be aware of this right to participate meaningfully in decisions regarding aspects of service.
Well, I should point out that we do have foreign language interpreters.
The Ethiopian interpreters.
So if we have to find a Urdu interpreter, we can do it by telephone if we can't find a live one. But in Northern Virginia, we're pretty lucky to be able to find almost any language.
It was scooped down one. All right, we've got that. So Mark already covered those things. I don't want to waste your time with that. So let's go to this one, employment issues. These are some different changes in the law sort of over the last few years. CSBs may hire someone as a direct care employee with certain misdemeanor and battery convictions if the convictions were substantially related to substance abuse or mental illness, and the person has been rehabilitated, and the person is not a risk to consumers based on his criminal history background and his substance abuse and mental illness history. So a direct care employee, obviously someone dealing directly with a consumer, these convictions with these caveats will not prevent a person from being able to be hired by a CSB. Okay, so disclosure requirements for mental health care providers. A mental health care provider must disclose records to the magistrate court, the patient's attorney, the patient's guardian ad litem, the examiner that he talked about, who is employed by the CSB's law enforcement officers. And if any harm results from the disclosure, the mental health care provider is immune from liability, unless bad faith or intent. This is the definition of a healthcare provider. We're not going to go through this, but you can see that it's very broad. Chiropractor, physical therapist, assistant, clinical social worker, licensed dental hygienist, health maintenance organization, pharmacist, dentist. So you can see that the definition of healthcare provider is very broad. We go to disclosure. Where an individual lacks capacity to consent or authorize disclosure of information, the provider shall obtain consent or authorization from an attorney in fact who's been appointed for the person. A healthcare agent appointed by the individual under an advance directive or power of attorney or a legal guardian. Psychiatric advance directives are something that have really become something that people are doing. I know that my students in my clinic are offering with supervision with a lawyer to help people fill out psychiatric advance directives. And I'll talk about that in a little bit, but this would be like a medical advance directive where you say if I get into a position where I can't make decisions or I'm incapacitated to make my own decisions and I want these things to happen to me or I want this person to make decisions for me. And I think that these are very good ideas for everyone, but especially for people who are directly affected immediately by mental health impairments in moments of capacity. Disclosure requirements for firearms. So in the past couple of years, as part of this overhaul, adds requirements of state background check for firearms. These questions have to be answered. Has the applicant ever been acquitted of a criminal charge by reason of insanity? Has the applicant ever been found legally incompetent or mentally incapacitated? Has the applicant ever been involuntarily admitted to a facility? And has the applicant ever been ordered to receive involuntary mental health treatment? These questions now have to be answered in applying to purchase a firearm.
Can I add into this that
Yeah.
if a person either volunteers for the 5 days of treatment that I told you about, their option at the beginning of the hearing, if they volunteer to go in for 5 days, or if we order their treatment after a hearing, in either of those instances, they lose their right to purchase, possess, or transport a firearm. And they go on the list that the state police keep.
Are they made aware of that?
Yes, we were required, because it's a Second Amendment right. Because it's a Second Amendment right, we're required by statute to advise them of that. And I should point out in the form that we use in Fairfax, it specifically recites that understand that if you do this or if you're ordered, that you lose that right, that they know that.
Well,
Does it
you
ever
use that.
stop somebody from, if they would have otherwise signed themselves in?
I'm sorry.
Has it ever stopped anybody if they would have otherwise signed themselves in and they found out about that and said, oh no, never mind?
I'm not probably.
Has
In
it
your
ever stopped? Has it ever prevented somebody?
Someone changed their mind because of that?
Yes, I'm glad you asked that question. Yes, some people say, oh, I want to think about this, when they were thinking about volunteering.
Yeah.
And then they'll go out and they'll say, can we have a recess? They'll go out in the hall and start twisting their parent's arm and saying, I won't be able to hunt again, I won't be able to protect myself. And I knew a special justice, he's not any longer, he went to the ministry, I think. He was a special justice in Harrisonburg, and they were much more liberal in disposing of their cases out there because every fall, it's hunting season, and it has a much greater effect on people out there. So it probably affected that court's view of who should be in the hospital or not.
Well, and this is true whether or not you can establish that you have regained, whatever capacity or whatever. I mean, this is a permanent thing. Okay, reporting to parents. Public universities must notify parents of students receiving mental health treatment. I believe this is controversial from my perspective because this might have a chilling effect on whether or not students want to go to get mental health treatment, which is what we want because they're stressed out, their boyfriend broke up with them, they flunked their exam. Anything else that we're doing when we're at that age, you want to encourage that type of thing. So, in my position, that this is somewhat troubling to me that public universities must notify the parents.
What age is student defined as? So as long as you're enrolled in a public university,
Right?
so you can be 26 and the parents have to be notified?
I think so, right? As long as you're a student at the public university.
I'm not as familiar with this part.
I don't believe there's an age cutoff. I don't.
This is new, though, isn't it?
And this applies to students that the school deems causing serious physical harm to himself or others, or will suffer serious harm from not protecting or providing for himself. So this is the takes a look at the criteria. No notification if a treating doctor opposes disclosure in writing.
Jane, do you know anything about this?
Yeah, I think the cutoff is whether or not the individual is independent of their parents. But I'd have to go back and look it up.
It's dependent students.
Yeah, it's a dependent.
Okay, so there you go.
I mean, that makes the law student can
Sure.
be however old, and their parents aren't involved.
Sure.
I think their parents are involved.
Okay, inpatient admission of minors over 14. Minors over age 14 who are incapable of giving informed consent can be admitted to inpatient treatment based on their parents' application. Incapable of giving informed consent is cannot understand proposed treatment or cannot make a rational evaluation of risks and benefits of treatment.
I should butt in here to say I didn't give you an overview of the juvenile commitment process, which is slightly different. It has a little bit different commitment criteria, and the procedure is a bit different, but there's a parallel proceeding for kids between 14 and 18 as far as having a hearing. I think if they're under 14, they don't really get a contested hearing.
Public and private universities can request full mental health records from students' high schools. So presumably this would be the same as the other one as far as who this applies to. And they must keep them confidential as required by state and federal law. There was recent legislation that repealed the law that kept the parents' mental health records privileged and confidential during a custody or visitation case, and repealed the law that a parent's mental health care provider cannot testify in such proceedings. Incompetent criminal defendants. The defendant must be, if you're going to release an incompetent criminal defendant, the defendant must be found incompetent and charged with a nonviolent misdemeanor. The defendant has not been restored to competency, quote unquote, after 45 days in custody. The judge must decide what to do. We either have to institute involuntary civil commitment proceedings, release without dropping the charges, or drop the charges. And it's important that there's an exception for people charged with sexually violent offenses that are found to be incompetent and determined likely to remain so for the foreseeable future, then reviewed for commitment as a sexually violent predator, which is a different proceeding, which I'm not all that familiar with. This is what we talked about before, psychiatric advance directives. Any adult capable of making an informed decision may make a written advance directive and can address any or all forms of health care, must be signed by the declarant in the presence of two witnesses, must specify what is not authorized, must specify whether anatomical gift, and may authorize an agent to take any lawful actions necessary to carry out the declarant's decisions. This is, I don't know if anyone's familiar with the Ulysses contract, but you might remember the Odyssey. Odysseus, as he's going through on his ship, he's going to go by the sirens, and the sirens, you may remember, were the beautiful women with the beautiful voices that no one could resist. And so you'd have bones of hundreds of thousands of sailors who'd gotten too close, they couldn't resist, and they go crash the boat and they die. So Odysseus wanted to hear the sirens. And so he asked his men to lash him to the mast, and whatever he said, don't let him go. So they lash him to the mast, and they sail on past. He's listening to the sirens, they're beautiful, they do whatever they do to every other man who goes through there, and he screams to them to let him go, and they don't. And so he survives. So this concept is sort of what an advance directive is. So it is essentially, if I get to a position where I can't make a decision, and I tell you to the contrary, I don't want this anymore, you are supposed to do what, or you have to do what the person told you before they reached an incapacitated state. So that's what a Ulysses contract is. Barring a statutory exception, in Virginia, it is unauthorized practice of law for a non-lawyer to assist in completion and execution of advance directives. Healthcare providers are allowed to assist in the completion and execution of advance directives. So make sure you check the ethics laws. You're not involving anybody in the UPL trying to get advance directives signed. Limitations of advanced medical directives does not apply to authorization of non-therapeutic sterilization, abortion, or psychosurgery. If the directive conflicts with the authority conferred by any emergency custody order, temporary detention order, involuntary admission, and mandatory outpatient treatment, the provisions that create the conflict will have no effect if the advance directive shall otherwise have. Clear and convincing evidence, we already talked about that standard. If the person is incapable of making an informed decision on his own behalf, and Mark already talked about this, so I don't think we need to cover this again. Psychotropic medications. This is something that Mark touched on, but one of the reasons that people don't like these medications is because of the side effects that they have. Many have very extreme side effects, including sexual side effects, weight, gaining lots of weight, lethargy, confusion, a lot of sleep. So there are very rational reasons why people don't want to take these medicines. And as soon as they feel better, like Mark was saying, feel normal, then they can say, I don't have to take this anymore, so that I can lose my weight and I can get my sex drive back and I won't be sleeping 15 hours a day. And that's how we get, falling back into, and so we have a cyclical problem. And that's not to say that everybody's that way, but that's one of the reasons why you would see that. Competency and capacity. We're going to talk about that later in the ethics part, the difference between those two. And that's that. So that's not a comprehensive overview of the mental health law system in Virginia. That's just sort of some notable developments that have happened over the last couple of years. And I'm interested, Mark, if you have any comments on any of those things and your views on sort of what the changes were, as a result, and especially with respect to the firearms issue. That to me is a bit of a hot topic.
Right. The only thing I didn't say about that is the statute does provide for restoration of the privilege, and you have to make application to the general district court, I think it is, can restore your right to have a firearm. I don't think the statute, I haven't look, I thought I might not. I don't think it provides any criteria. I think it may just be a good cause situation. That may be the criteria. And if anybody's really interested in this, there was a really excellent article in the New York Times about a year or two ago that covered this, talking about how in some states like California, it's very difficult to get your right back. But if you're in Texas, they don't even ask you a question. You have a petition, you got your right back. So.
All right, so does anybody have any questions about those things? Are these slides available to them?
They have.
Okay. So Mark, I guess that's the end of that. I wanted to see if we could have a discussion for a few minutes about a couple of things before our ethics. As far as I'm curious about the Commonwealth's attorney representing the petitioner in involuntary civil commitment proceedings. Do you have any kind of issue with that, or does that make sense to you?
Well, I used to represent the respondents, and before I was appointed special justice, and actually kind of liked it because one, they didn't like doing the cases, the Commonwealth's attorney, where we are, and they would put any energy into it, really. And they would do it the same way they do. In Fairfax, they're very busy, and they don't have time to reflect on certainly none of their large docket of misdemeanor cases, and they kind of treat this as a stepchild. I hope I'm not slandering my prosecutorial colleagues up in Fairfax. But it was kind of like that. Nobody really liked it doing these cases. But I can tell you they didn't settle often. What happens with most appeals, in my experience, I don't know if this addresses your question, Nathan, but is that we would have the 29-day cure because they would set these appeals for hearing on Thursday before the circuit court judge. And the doctor would almost inevitably release them on Wednesday to try to root out the appeal.
And another thing I wanted to ask you about procedurally is, have you ever had a respondent insist on representing themselves? And the reason I'm asking that is because there's a Supreme Court decision, and it's not too long ago, Supreme Court of the United States, Edwards versus Indiana, where that was a criminal case, and the defendant was found not competent to stand trial and wanted to represent himself. And he was found competent to stand trial, but the U.S. Supreme Court said just because you were found competent to stand trial does not mean you can serve as your own lawyer. So I'm curious if you have any examples of times where people wanted to represent themselves and in fact were successful at being able to represent themselves.
Yes. The last time I was on 3 weeks ago, I think I had 2 guys who wanted to represent themselves. And I try to talk them out of it every time. I ask them, have you been involved in this before? Do you know how complicated it is? Because the law is, you heard me talk for an hour about it. It's got a few pitfalls here and there. And, you know, sometimes they're busy enough that they're going to insist on it anyway. So then I tell the court appointing attorney, why don't you just be the standby attorney? And they often don't know what to do. They're the deer in the headlights when it gets to be their turn to ask questions. To cross-examine the witnesses seeking their hospitalization. It's not usually very effective and they can't come up with questions. But, that's the best way I can think to handle it. Most of the time you can talk them out of it representing themselves, but sometimes if they insist, stand by counsel.
One of the things that we talk about in the clinic is what is mental illness, and then also what is dangerousness. Many times in these types of conversations, we talk about mental illness as if it is you are either mentally ill or not, and you are either dangerous or not. And obviously, mental illness is a complicated thing, and if you're going to stay for the second part of this, which is the health law, CLE, we'll have a psychiatrist here who's a friend of mine from the VA who said that psychiatry is more part of the science. And obviously, there are any illness, to me, I sort of think of it as a spectrum. I think of it as, you know, there's any number. I mean, there's not a black line. We step over it and now we're mentally ill, but there's some kind of spectrum. And obviously, it would not be linear, but it would be multiple dimensions because we've got different diagnoses and different types of mental illness. But the fact that we're treating these things almost as the same by calling them mental illness, I think sometimes gives problems for people trying to make decisions about what to do with people who are exhibiting symptoms that would suggest mental illness. And then likewise, the issue of dangerousness. Is something dangerous or not? And then oftentimes I think violence is interchangeably used with dangerous. And is something violent always dangerous? Is something that's dangerous always violent? And so the way we talk about these in broad sweeping terms, I would encourage you all to think about what does mental illness mean? And the diagnosis, we use the DSM and we run run the symptoms along and put it through a grid and it spits out what the differential diagnosis is. And it depends on the symptoms. And the other thing is, mental illness is static. Mental illness often is not static. Mental illness often ebbs and flows and waxes and wanes with respect to severity of symptoms, so certainly depending on what the mental illness is. Episodes of psychosis, certainly you need not always be thoroughly psychotic. I mean, do you run into these issues where, you know, you mentioned this, I think, in passing, but where you've got somebody who yesterday was floridly psychotic, was threatening to stab himself in the chest, was talking about the president controlling him, and now today he's in there and he's in a nice suit and he's talking to you like we're talking together. Did that happen to you in your garage?
A lot, and I should add, it's one of the features I like about the Virginia system is having an appointed independent evaluator. Because I think if you go to other states, you can have any mental health expert, also a psychiatrist, and you don't have an independent view. And you know, sometimes that's value laden. The psychiatrist has a goal, which is to commit this person. At least here you have somebody, and sometimes the independent evaluator gets wrapped up in it. They have a view that this person really needs it, and therefore I'm recommending it. But I wanted to say that in my experience, and this is not a knock on psychiatry, but the independent evaluators in Fairfax also rotate with us, and they get to know us very well, the three special justices. And they know what our predilections are. They know which one commits the least, and which one commits the most, and which one views this situation as dangerous or this is not so dangerous. And I think that's helpful because when they're making their evaluation, they're able to articulate the very specific points that we're looking for to make our decision. In other words, this person was very threatening to their parent, and it happened weeks ago, and I did a commitment hearing with them 3 months ago, and they were actively psychotic then. It was the same kind of behavior. So based on my experience, i.e., I'm recommending to you that you need to hospitalize this person. Another comment I should make about that is, mental health experts, I think, basically agree that you cannot predict human behavior, number one. Humans can do anything, right? You can be totally wonderful now, and then an hour from now you can shoot somebody.
Well, and in fact, Barefoot versus Estelle is a United States Supreme Court case in which the APA filed an amicus brief, and in that amicus brief, they said that 2 out of 3 times psychiatrists are wrong in predicting future dangerousness. 2 out of 3 times the APA themselves. And so you're better off flipping a coin and get more likely right. And the best predictor, in just one second, John Monahan is a professor at UVA. He's sort of a patriarch in thinking about mental illness. And his studies and the other studies that I have read and that have been published suggest that the best indicators, the best predictors of future violence are past violent behavior, mental illness with substance abuse. Those 3 things together are the best way to predict whether someone will be violent.
And of course, it's a statistical analysis. It doesn't relate to the individual. I mean, you can try to apply it. So most mental health experts that I've heard about, read about, talked to will say, we really can't tell you what this person's behavior is likely to be more than 6 days from now. 6 or 7 days is what they'll say, about a week. So if they tell us that, yeah, I think this person is going to cause harm in the near future, they're really talking about the next several days. Yes. Oh, I'm sorry.
I had a case where I used the former president of the American Psychiatric Association, and I asked him about predicting threat, expecting to get an answer that would just enlighten me, and just exactly what you said. He said the greatest predictor of threat was drug and alcohol use, past violence. He said that if you have a ongoing therapeutic relationship with the client, really ongoing where they're forthcoming to therapy, that just maybe, a good psychiatrist or psychologist could predict threat for a day. And I was sort of blown away by that, because I think we live in a society where we think that doctors can wave their little magic wands and fix everything.
No, and then they put it on us, that we're supposed to make that prediction.
Which I can't imagine how frightening that must be day to day.
And I think a lot of us will make predictions one way or the other based on, I hate to admit this, but I think it's true, the gut. Yeah, and does this person, and one of the things we're supposed to take into account is after observing the person and getting their demeanor. But as Nathan's pointed out, it can change. So very often I'll hear good stuff showing that the person is a risky guy, and they come in and they're just as clear and persuasive as they can be, and they answer all the points, just like a lawyer. He said, I'm going to do this, well, let me say this about that. And you think this person's appearing very impressive now, and I have to make a prediction. Well, given what I've heard about their past and how they're presenting today, what do I do? Sometimes it's very scary.
Well, and in that case, Barefoot versus Estelle, there was a challenge to the experts, the state's experts, who were psychiatrists testifying, and there were other problems in the testimony, like it was 110% absolutely sure he would commit a violent act in the future, which obviously no jury would ever hear in Virginia. But when even though the APA is saying, we're wrong 2 out of 3 times, and that was part of it. The Supreme Court said we defer to the psychiatrists who better to predict than the psychiatrists. We can't do it. We're judges and lawyers, and so who else do we refer to? But it's interesting to think about when they themselves believe they're wrong, but who else do we refer to, right? Yep.
Recently, I've had some cases where the CSB has said this person meets the criteria, and they give their reason for it based on their reason evaluation. But
You do disability, right? Disability?
He's a special
well,
Oh,
this
wow.
is
Right.
and then the independent examiner will say just the opposite based on the person doesn't meet criteria. And then some of the mental health specialists say the MR, the basic functioning, substance abuse, and personality disorders don't fall under the DSM-Axel-1, and so there's no way they can be a mental illness. But my gut feeling in some of those cases is that the person does have a mental illness. And so my question is, do we just have to rely on the Axis 1 DSM diagnosis? Because in looking at the statute, it doesn't say we have to have a DSM-1 diagnosis to find mental illness.
Yeah, I would think that, I don't, what do you think?
You know what I do? I'll tell you I've kind of taken over the IE examination to this extent. After the petitioners put on her witnesses, then I will call the IE as my witness. And following the statutory criteria, I'll say, did you personally examine this person? Yes. When did you do that? Yesterday, and I saw him again this morning. As a result of your examination, did you find probable cause to believe they meet any of the 3 criteria? The commitment criteria? Yes. Which ones were they? And then they'll tell me which ones. Then I'll ask, did you arrive at a diagnosis? Now, not DSM, just did you arrive at a diagnosis? Yeah, or, well, by history, they might say, not my diagnosis, but by history they have this. Or they'll say, yeah, my diagnosis is this, rule out that. In other words, they're uncertain, because a lot of times they don't have enough information to arrive at a firm diagnosis. And they'll say, well, if I don't have evidence that they're mentally ill, other than, the anecdotal evidence about their behavior, then what am I going to do? I think that's why the IE is there by statute to provide the mental illness piece of the commitment criteria. Mentally ill, and as a result of that, blah, blah, blah. So if they tell me, I don't, but they never do. They'll say, oh, adjustment disorder, or or psychotic disorder, not otherwise specified. That's the most popular one. So they don't allude to DSM, but they'll tell me something. Virginia.
Yeah, the Virginia code says they have to be mentally ill, and then you go to the statutory definition in 37.2 of mental illness. That's not a DSM diagnosis.
Right.
It says mental illness means a disorder of thought, mood, emotion, perception, or orientation that significantly impairs judgment, behavior, capacity to recognize reality, or ability to address basic life necessities, and requires care and treatment for the health, safety, and recovery of the individual or for the safety of others. And that's your operative definition, not the DSM diagnosis. So you apply the facts to that definition.
Right. But almost always they'll have a diagnosis. And one reason I think that is because I don't think on many occasions that the pre-screener is even going to recommend, unless, in our jurisdiction anyway, unless there's enough there to arrive at diagnosis. And that's something I should mention. I think one of the reasons why, one of the factors, not the primary or main factor, but one of the reasons why I think the commitment rates are so disparate around the Commonwealth is because there are different levels in which the pre-screener views the commitment criteria. Some are much easier to think that they're met, some are more strict before they'll recommend detention.
But over 3 years or even weeks or months, once the person gets in the hospital, the diagnosis very often changes, and to expect a mental health professional to diagnose somebody on the spot unless they have a history is very difficult. So you'll see lots of varied diagnoses, and diagnoses really don't mean anything except for the particular treatment interventions that are going to be used. And psychiatry is constantly evolving, and medications and treatment are evolving. So just putting a diagnosis on somebody is very precise.
That's why I think that the basic predicate, and I can say, I think fairly, that I place a lot more emphasis on the other prong, which is what have they done. And I'd ask you all to consider that. What is serious harm? And Jane, we debated this hotly when the commission was reforming the criteria. What is serious harm? Does it mean a cut in the arm? Does it mean something that requires a Band-Aid? Is it broken limb? How do we weigh that?
Is it risky behavior?
Oh yeah, of course.
Like when you're walking along a narrow ridge.
Right. How about attacking somebody with a butter knife, plastic butter knife? Something you get at the cafeteria. Is that enough to put somebody in the hospital?
Is that what a reasonably prudent man?
We've never encountered that.
Internationally spending the money, like once the petitioner was the wife because the husband was going out just throwing away the money.
That's a great one.
I think so.
Because Professor Bonnie and Professor Money and is it Bruce Cohen who's joining today? Those three wrote this
Bruce
thing.
knows I'm coming today.
Oh, okay.
He was writing on it.
They wrote this explication of the new commitment criteria. And one of them was exactly what you said. If somebody goes out, let's say they lose custody of their child because of mental illness, or they spend all their money, they go out and buy 3 cars in an afternoon, and they can't afford it, is that grounds to put somebody in the hospital? They argue that it can be.
And I might disagree exactly with Mr. Cho, who committed the worst mass shooting ever. There's no history of violence, no history of drug abuse, no history of violence.
Right.
None.
5 minutes before ethics. Any other questions or comments? I mean, I think it is interesting thinking about, serious harm, mental illness, and dangerousness and violence. Certainly a topic that I think is not readily defined, readily available. And I think, like you're saying, a lot of things go with your guts or how you feel, about the situation right now under the circumstances. Given all this stuff, what do you feel?
Well, the attorney who represents, the assistant county attorney who represents the petitioner for us, practiced in D.C. for 10 years before she came to Fairfax, and she did the same job in D.C. for 10 years. And she noted that there's a wealth of case law there that tells the judge what is dangerous and what is inability of care. And I remember when we were studying the commitment criteria, changing it from imminent danger to substantially likely to cause serious harm in the near future. Montana had an imminent danger standard. They had a wealth of case law. But, Virginia doesn't. I think there are 1 or 2 Virginia Supreme Court cases that address involuntary commitment, and neither one of them addresses the criteria or what constitutes the criteria. And that's another reason I think you get this great variance, because, what I think in Fairfax versus what somebody in Kingston gets is obviously be very different.
Can I ask you one last question? So since the language has changed, have you yourself in your practice been committing more people than you did when the language was substantial likelihood?
I don't know about the numbers. Our community services board keeps numbers, and they keep them for each special justice. Quarterly we meet and we see these things, and they'll show that I maybe commit people 20% of the time, and special justice B commits them like 33% of the time. But every case is different.
I mean, after the statutory language changed.
Well, that's what I'm saying. I don't know that, no. I don't know that you can really measure that anyway. I can tell you that I think it's my opinion that the statutory language liberalized and made it easier to commit. I think substantially likely to cause harm in the near future makes it easier to commit than imminent dangers.
There's a lot of people disagree.
Really?
Well, I think in some respects they were.
Really?
And that's part of that explanation is interesting that you were referring to. There's some language in there that suggests that this won't really make a big difference.
I don't think that it has. I think over the total number of cases, I don't think it made a substantial difference. But the way I view the case certainly is I think it's easier to commit somebody that they're substantially likely in the near future to cause harm as opposed to imminently dangerous. I like to go with criteria better because I think it made it real clear.
Problem is, you're letting people go that you shouldn't, because the language is so precise areas of life.
I do that now. I let people go now that I don't feel good about, who I know are mildly psychotic, but there's no showing that they're likely to cause serious harm in the near future.
You can't make it human system perfect.
Right. Exactly. So you do the best you can.
Okay, we've got to stop this weekend.
Yes, why don't we take just a couple of minutes? It's 10:57, so maybe 11:02, and then we can start